I have always believed that the most dangerous weapon in England is not a knife, nor a shotgun kept broken over the arm in a game bag, but a fountain pen resting quietly in a solicitor's breast pocket. My husband never understood that. His mother never understood it either, and it was her ignorance, in the end, that cost her the only home she had ever loved. I should tell you plainly, before I tell you anything else, that I am not a cruel woman. I did not set out to ruin anybody. I set out to protect a promise my grandmother made to me when I was 11 years old, standing beside her in the long gallery at Winterbourne House with the rain coming sideways against the mullioned windows. She had taken my chin in her papery hand and said, "This house has outlived better people than your Uncle Rupert, and it will outlive whoever tries to take it from you too, provided you are clever enough to let them try." I did not know, at 11, what she meant. I understood it perfectly by the time I was 34, standing in my husband's mother's drawing room with a glass of sweet sherry I did not want, listening to the two of them discuss my future as though I were a horse to be sold at Newmarket. My name is Eleanor Ashford, though for the first 31 years of my life I was Eleanor Hartley, and it is the Hartley name that matters to this story, because it is the Hartley name on the deed to Winterbourne House, and it was the Hartley solicitor, a dry, precise, entirely unsentimental man named Mr. Alastair Pemberton, who taught me that the law rewards patience far more generously than it rewards anger. Winterbourne House sits at the head of a small dale in the West Riding, 3 miles from the nearest village, with a beech avenue running up to it that turns the color of old brass every October. My grandmother, Constance Hartley, was born there in 1938, in the same bedroom in which I was born 50 years later, because my mother, her only child, had gone into labor early during a visit and refused, with the particular stubbornness that seemed to run through the women of my family like a fault line through limestone, to be moved to hospital in time. I grew up mostly in Harrogate, in an ordinary semi-detached house with an ordinary garden, but Winterbourne was where I spent every summer and most Christmases, and it was, from a very early age, more truly home to me than the house I actually lived in. My grandmother was, by the time I knew her, a widow of considerable dryness and even more considerable competence. She had run the estate's 400 acres of let farmland herself for 30 years, after my grandfather died, and had done so, the local land agent once told me, a great deal better than he ever managed it, God rest him. She did not believe in sentimentality, but she believed absolutely in loyalty, and she taught me, over the course of a great many summer afternoons spent going through estate accounts at the long table in the library while other children my age were at the seaside, that the two were not the same thing at all. Sentiment, she told me once, is what people feel about a house. Loyalty is what a house requires of you in return, and it is considerably more expensive. I did not understand, then, that she was training me for something. I understand it perfectly now. She had watched, in her own long life, 2 cousins lose family houses to exactly the sort of quiet, well-mannered predation that would later come for Winterbourne, a husband who signed over half a farm to cover gambling debts nobody discovered until the bank came calling, a nephew's wife who persuaded an aging uncle to place his estate for tax purposes into a company of which she happened to hold the controlling share. My grandmother had watched both of these slow catastrophes unfold from a comfortable distance, had attended both funerals that followed within a few sad years of each ruin, and had drawn from them a conclusion that she wrote, almost word for word, into her own will 30 years later, that the danger to an inheritance rarely announces itself as danger. It arrives instead dressed as family feeling, wearing the ordinary vocabulary of protection and fairness and doing the sensible thing, and by the time anybody recognizes it for what it is, the papers are usually already signed. Julian Ashford was, by any objective measure, a handsome disappointment. I met him at a fundraising dinner for the Dales Air Ambulance in the spring I turned 29, and he had the particular charm of a man who has never once in his life been told no by anybody who mattered. He wore his father's old dinner jacket, slightly too broad in the shoulder, and told me a story about sailing off the coast of Cornwall that I later discovered, from his own mother, to be almost entirely invented. He had, in fact, been dreadfully seasick on the one occasion he had gone out on a friend's yacht, and had spent most of the crossing to Guernsey lying flat on the cabin floor. I found the original story, at the time, endearing. I have since revised that opinion considerably. We married 18 months later at the parish church in the village below Winterbourne, with my grandmother, by then 81 and using a stick, though she would have died rather than admit she needed one, sitting in the front pew in a hat the color of a wood pigeon's breast. Margaret Ashford, my mother-in-law, sat opposite in navy, and I remember thinking, even then, on my wedding day, that she looked at my grandmother the way a surveyor looks at a piece of land he intends one day to buy very cheaply. Margaret had been widowed young. Her husband, Julian's father, had been a solicitor himself, though not, I would come to learn, a very good one, and had left the family with a handsome Georgian house called Ashford Manor and considerably less money than the house suggested. Margaret had spent the subsequent 20 years maintaining the appearance of comfortable gentility on an income that did not support it. The roof was reletted only in sections, as funds allowed. The drawing-room curtains were the same ones I saw in photographs from Julian's christening, turned twice and rehung. The second gardener had been let go the year Julian left for university and never replaced. There is nothing, I have since learned, more dangerous than a proud woman running out of money quietly, in a house too large for her means, watching her son marry into a fortune she had not managed to secure for her own family. My grandmother spoke to me only once about Margaret, on the morning of the wedding itself, while I stood in front of the long mirror in the blue bedroom having my veil pinned by an aunt who talked a great deal and noticed very little. "She is not a wicked woman, that one," my grandmother said, watching me in the glass. "She is a frightened one, which in my experience is considerably more dangerous, because a frightened woman believes everything she does is justified by the fright. You make her sound like an animal in a trap." "She is rather like an animal in a trap, my dear. The question you must ask yourself, every single year of your marriage, is not whether she loves you. It is what she will do, and permit her son to do, if she ever believes the trap is closing on her again." I laughed, that morning, the easy laugh of a bride who believes love has settled every future question in advance. I did not laugh again about it for a very long time. My grandmother died the winter after our wedding, quietly, in her sleep, in the same room in which she and my mother had both been born, and I have been glad, in every year since, that she went before she had to watch any of what came next, though I have sometimes wondered, uncharitably, whether she had in fact anticipated the whole of it, and had simply run out of time to warn me any more plainly than she already had. She left Winterbourne House, its 400 acres of let farmland, and the whole of the Hartley estate to me, in trust, with a codicil that struck everyone except Mr. Pemberton and myself as eccentric. The property was to remain in my sole name, unencumbered, for a minimum of 10 years from the date of her death, in recognition, the will read, of my granddaughter's understanding that inheritance is not the same as ownership, and ownership is not the same as safety. Julian called it your grandmother's little joke. Margaret called it, more than once and never quite out of my hearing, frightfully old-fashioned, don't you think, to leave a married woman's house entirely out of her husband's name. I said nothing, both times. I had learned that from my grandmother too. For the first 3 years of our marriage, I told myself that Julian's idleness was a temporary condition, like a head cold, that would clear once he found the right occupation. He tried, briefly and without distinction, to be a wine importer, a venture that produced 11 cases of unsold Rioja still stacked in our cellar and a great many stories about the Spanish market that never seemed to resolve into any actual income, and then a partner in a friend's property development scheme in Harrogate that collapsed, owing several people a great deal of money, none of it, thankfully, mine, because I had learned by then never to sign anything he put in front of me without reading every word twice, a habit he found, at various points, charming, tedious, and finally, though he did not say so until much later, and by then it hardly mattered, infuriating. It was the autumn of our 4th year that I began to understand what was actually happening, and I understood it not through any dramatic confrontation but through the ordinary, grubby mechanism of a study door left ajar on a Sunday afternoon at Ashford Manor, where we had gone, as we did most Sundays, for lunch. I had gone through to fetch my cardigan from the drawing-room and heard, through the door to Margaret's small study beside the stairs, my own name. "Won't simply give it to us, Julian, she's not a fool, whatever else she is. It will have to look like her idea, or at the very least like a kindness to you. A trust. Something that sounds protective. Women like Eleanor respond to the language of protection. She won't want to put Winterbourne in a trust with your name on it, mother. She's careful about that house. Then we don't put my name on the papers where she can see it first. We use the solicitor Rodney recommended, the one who does the conveyancing for the golf club, not that dusty old man of her grandmother's. We structure it as a family trust, for tax purposes, we'll say, to protect the estate from death duties when she goes, God forbid, and by the time it's drafted the beneficial interest sits with the Ashford Family Trust, of which you and I are the trustees, and she is a life tenant. She keeps her nice house to live in. We get the asset. It is not stealing, Julian, whatever tone you're using. It is estate planning. And if she asks questions? She won't, if you're the one who asks her. She still looks at you the way she did at your wedding, poor girl. Use that. It's the only useful thing you've done in 6 years. I stood quite still in the passage with my cardigan over my arm, and I did not go into the study, and I did not confront either of them at the lunch table 20 minutes later, where Margaret asked me, with every appearance of warm interest, whether I had thought any more about making sensible provisions for the estate, given how unfair inheritance tax is on families like ours. I said I would think about it. I smiled. I ate my lamb, and the roast potatoes Margaret always did rather well, crisp at the edges and soft within, and I have never in my life eaten a meal with less enjoyment or greater attention. I watched Julian pass the mint sauce to his mother with the small, practiced courtesy of a man who has been managed his entire life and has never once noticed the managing. I watched Margaret refill my wine glass before I had quite finished it, a habit of hers I had always taken, until that afternoon, for simple hospitality. I drove home that evening with the window cracked open despite the cold, because I found I needed the air, and Julian, beside me in the passenger seat, remarked twice on how quiet I was, and I told him, twice, that I had a slight headache, which was not, strictly speaking, a lie. I telephoned Mr. Pemberton the following Tuesday and asked whether I might come to his office in Skipton rather than have him come to the house, which was, I said, in rather a state. He did not remark on the strangeness of the request, because Alistair Pemberton had been my grandmother's solicitor for 40 years and had learnt, in that time, never to remark on anything until he had heard the whole of it. His office occupied the first floor above a chemist's shop on the high street, 3 cramped rooms smelling of old paper and pipe tobacco he no longer smoked but had never quite stopped smelling of, and I sat across the desk from him in the same chair, I imagine, in which my grandmother had sat 100 times before me, and told him everything, the study door, the phrase beneficial interest, the golf club solicitor, the word trustees. He listened with his hands folded on the blotter and his glasses pushed up into his white hair, and when I had finished he took the glasses off entirely and set them down beside a paperweight shaped, absurdly, like a small brass pig, and was quiet for a long moment before he spoke. "Your grandmother told me, 3 years before she died, that this would happen eventually," he said. "Not the particulars. She wasn't a witch, whatever the village thought. But she said, and I wrote it down because she asked me to, that if anybody ever tried to move Winterbourne out of your soul name, I was to remember that a trust, my dear Eleanor, is only as safe as its worst clause, and only as dangerous as its best one." "What did she mean?" "She meant," said Mr. Pemberton, "that you are about to be offered the opportunity to write a trust deed. Nobody asked what should be in it. They asked whether you would sign one. Those are different questions, and only one of them is a trap." He explained it to me slowly, over the better part of 2 hours, with a pot of tea going cold between us and the light fading over the rooftops opposite, with the patience of a man who had spent 4 decades watching families destroy one another over exactly this kind of arrangement. A family trust, properly drafted, requires contributions from more than one party to look, to any outside observer, a bank, an accountant, a suspicious wife, like a genuine act of mutual estate planning rather than the quiet transfer of one woman's inheritance into her husband's family's control. If Margaret and Julian wanted the trust to look legitimate, wanted it to survive scrutiny from my own solicitor, they would need to put something of their own into it. Not much. A token. A gesture of fairness. But something. "And if they do," said Mr. Pemberton, "then whatever they put in is subject to whatever conditions the deed contains. All of it. Every asset in the trust, on equal terms, unless the deed specifies otherwise. Which means, Eleanor, that the question is not whether you should refuse to sign. The question is who drafts the document, and what is written in Clause 4. "Why Clause 4? "Because," he said, and here, for the only time in our long acquaintance, I saw Alistair Pemberton look almost delighted, "nobody ever reads Clause 4. They read the preamble, which flatters them with fine language about family and provision. They read the schedule of assets at the back, where there I go straight to the number and the property list. Clause 4 is where the machinery lives, the ordinary, boring, technical protections that every trust needs and that no layman has ever read past the heading of. It is where you put the thing you don't want found until it matters." I asked him, before I left that evening, whether what he was describing was entirely honest. He considered the question with the same gravity he had given everything else that afternoon. "It is entirely legal," he said, "which is not always the same question, though in this particular case I believe the two happen to coincide. I am not proposing that you deceive anybody about what they are signing. Every word of the document will be exactly what it appears to be, available for their own solicitor to read as many times as he likes. I am proposing only that you allow 2 greedy, careless people to believe they understand a document better than they do, and that you decline to correct that impression on their behalf. There is no law in England, Eleanor, that requires you to read a contract aloud to the other side." I did not refuse Julian's careful, rehearsed suggestion, 3 weeks later, over dinner at our own kitchen table, that we think about protecting Winterbourne properly, darling, now that we're thinking about starting a family, a sentence so transparently borrowed from his mother's mouth that I had to look down at my plate to keep my face still, because we had not, in point of fact, discussed starting a family in the better part of a year, and I understood at once that the phrase had been chosen for its effect on me rather than for its truth. I said I thought it sounded sensible. I said I had heard trusts could be complicated and asked whether we ought to use someone independent, not just your mother's usual man, so it's all seen to be fair. Julian, delighted at how easy I was making it, agreed enthusiastically, and even suggested his own idea. He believed, though I had planted it as carefully as a bulb in October during a conversation about fairness the week before, that his mother put Ashford Manor into the same trust, so it isn't just your family giving something up, so it's proper, and even, and mother's protected too. I remember very little about the weeks that followed except the peculiar sensation of living two entirely separate lives inside the same house, the ordinary one, in which I discussed curtain fabrics and half-term plans and whether the Aga needed servicing, and the other, quieter one, conducted almost entirely in telephone calls made from my car in the supermarket car park and letters collected from a post office box in Skipton that Julian never knew existed, in which I was slowly, patiently helping two people build a trap they believed was entirely their own idea. Margaret did not love the suggestion when Julian first raised it to her. I know this because I was there, at Ashford Manor, ostensibly helping choose curtain fabric, when he raised it, and I watched a woman who had spent 2 decades protecting the one asset she had left go quite pale for a moment before recovering herself with the smooth, practiced composure of somebody who has spent a great many years learning not to let her face show what her mind is doing. "It's a formality, Mother," Julian said. "Nobody's taking your house away. It just sits alongside Winterbourne in the trust deed. Looks fairer. Eleanor's solicitor will want to see that it isn't all one-sided." "And whose solicitor is drawing this up?" "Rodney's man. Fenwick." "Very sound. Does all the clubs work?" I watched Margaret do the arithmetic that I had, by then, already done twice over on her behalf, that a solicitor who did all the club's work was a man who wanted to keep doing all the club's work, and would draft whatever his most important clients asked him to draft without asking many inconvenient questions, provided the paperwork looked correct on its face. She agreed, in the end, because the alternative, refusing to contribute anything at all, would have exposed the whole scheme for exactly what it was, in front of me, and Margaret Ashford was too proud and too confident in her own cleverness to believe that could happen. "Well," she said at last, folding her hands in her lap, "if it protects the family properly, I don't see why not," and I saw, in the small, tight movement of her jaw, exactly how much that sentence cost her, and understood, not for the first time, that pride and greed make very poor traveling companions, because each is constantly persuading the other to take one risk too many. Mr. Fenwick's draft trust deed arrived at Mr. Pemberton's office on a wet Thursday in February, 11 pages of the driest, most self-satisfied conveyancing prose I have ever had the misfortune to read, establishing the Ashford family settlement with Julian and Margaret Ashford named as trustees, myself named as a beneficiary and life tenant of Winterbourne House, and both Winterbourne House and Ashford Manor listed in the schedule of trust property, to be held for the benefit of the family, in perpetuity, administered at the trustee's discretion. It was, Mr. Pemberton told me, exactly the document he had expected, technically competent, morally indefensible, and entirely legal, provided I signed it freely and with proper advice, which was precisely why they had allowed my solicitor to see it at all. A signature obtained under advice cannot later be challenged as coerced. "They've made one mistake," he said, tapping the schedule of assets with one dry finger. "They've put both properties in on equal terms. No differential clause protecting Ashford Manor above Winterbourne. Fenwick's either lazy or arrogant, and in my experience it's usually both. He assumes nobody on your side will ever have cause to invoke any clause against the trust property, because why would you sabotage your own house? He hasn't imagined a version of this where the danger runs the other way. We amended nothing in Mr. Fenwick's document. That was Mr. Pemberton's particular genius, and I have thought about it many times since. We did not fight the deed. We did not strike out a single line, or send back a marked-up draft bristling with red ink that would have alerted Fenwick, or Margaret, or Julian, to the fact that anybody on my side was reading with real attention. We simply added one clause, in the plain, unremarkable style of every other clause in the document, in a position where it would look exactly like the ordinary protective boilerplate that appears in 99 trust deeds out of 100 and is read, if it is read at all, in the same half-second of professional skimming that a bank manager gives to the standard terms on the back of a mortgage offer. Clause 4, as it appears in the final, signed, and, I promise you, entirely valid deed of the Ashford family settlement, reads as follows: 4. Forfeiture and reversion. In the event that any trustee, whether acting alone or in concert with any other trustee or third party, shall attempt, whether directly or indirectly, to sell, mortgage, charge, transfer, sublet without consent, or otherwise dispose of or encumber any interest in the trust property, or shall attempt to remove, evict, or curtail the life tenancy of the beneficiary named in Schedule 1 without her written consent freely given, or shall be found by a court of competent jurisdiction to have procured the execution of this deed by any material nondisclosure or misrepresentation, then upon such event the entire beneficial interest in all trust property, without exception, shall immediately and irrevocably revert absolutely to the said beneficiary, and the offending trustee or trustees shall thereupon be removed and shall hold no further interest, legal or beneficial, in any asset of this settlement. Mr. Pemberton read it aloud to me once, in his dry Yorkshire voice, and then set the paper down and said, "It is, if you will forgive an old man his pride, rather an elegant piece of drafting. It looks like the kind of boilerplate protection every family trust contains, to guard against a rogue trustee absconding with the silver." Fenwick's Jr. will have seen 100 clauses that read exactly like it and will not think twice. But it does something rather more particular than the ordinary version, Eleanor. Read it again. It doesn't only protect Winterbourne. It protects your tenancy of Winterbourne, which your husband and his mother are, at this very moment, quietly planning to end the moment it suits them, once the trust gives them the standing to do it. And any breach of that particular protection doesn't simply return Winterbourne to you. It forfeits the whole settlement. Both houses. Absolutely. To you alone. They'll never breach it, I said. They'll be too careful, once it's signed. Mr. Pemberton looked at me over his glasses with the particular expression of a man who has watched greed operate at close quarters for 4 decades. "My dear," he said, "they are not careful people who have learned to behave carefully for one afternoon in a solicitor's office. They are careless people who have simply not yet been caught. Give them 18 months of feeling secure, Eleanor, and I promise you, they will breach it themselves, and they will do it so plainly that no court in England will hesitate for a moment." He was wrong, in the end, only about the number of months. The signing took place in April, in Mr. Fenwick's chambers above a bakery in the market town, with the smell of hot cross buns drifting up through the floorboards and Margaret wearing a suit the color of a magpie's wing, entirely certain that she was watching the successful conclusion of 2 years' patient work. Julian signed first, with the easy flourish of a man signing a restaurant bill, and made some small joke about finally being on the deeds of something, which nobody in the room quite laughed at, though Margaret smiled the tight, indulgent smile she reserved for her son's jokes at the best of times. Margaret signed second, more slowly, reading, or appearing to read, each page before turning it, and I watched her eyes move once, briefly, down the 3rd page, skim across the heading Forfeiture and Reversion in bold type at the top of Clause 4, hesitate for perhaps a second and a half, and continue past it to the schedule at the back, exactly as Mr. Pemberton had predicted, because the eye of a woman looking for her own name in a document always goes to the number and the property list. Never to the middle paragraphs of legal machinery she assumes exists only to protect her. I have wondered, since, what would have happened if she had paused for 3 seconds instead of 1.5. I do not think it would have changed anything. I think, by that point in the afternoon, with the champagne already ordered for lunch and the whole architecture of her plan so nearly complete, she would have read the words and simply not believed they could apply to her. I signed last. My hand, I remember, was entirely steady, which surprised me a little, given that I understood, far better than either of the 2 people in that room with me, precisely what I was signing away and precisely what I was, in the same stroke, setting a trap around. Mr. Fenwick, a plump, pleased man with a signet ring he turned constantly on his little finger, witnessed all 3 signatures with the brisk satisfaction of a man collecting a fee he considered thoroughly earned, and told us, as he blotted the final page, that it was always a pleasure to see a family settlement conclude so amicably. One sees so many that don't, in this line of work. We went, afterwards, to a hotel in Skipton for lunch, and Margaret ordered champagne, and made a small toast to the family, all together now, properly, and I raised my glass and drank to it, and felt nothing that showed on my face at all, and watched Julian's hand rest, for a moment, over his mother's on the white tablecloth, in a small gesture of triumph neither of them thought I would ever understand the meaning of. I had expected, in the months that followed, to feel something like satisfaction, or at least the grim, settled patience of a woman waiting for a trap to close. I did not expect the particular, exhausting strangeness of continuing to be a wife during that time, of sitting across the breakfast table from a man I now understood, with total clarity, had agreed to conspire against me, and passing him the marmalade, and asking whether he'd slept well, and meaning, almost despite myself, a fraction of the question. Julian did not become, in those 11 months, more obviously unkind. That was, I think, the strangest part of it. He remained exactly the man I had married, charming, idle, affectionate in the easy, unexamined way of somebody who has never had to work very hard at affection because it has always been accepted without question. He bought me flowers, twice, for no occasion at all, and I found I could not decide, arranging them in the good glass vase from the dresser, whether the gesture was guilt finding an outlet it did not recognize as guilt, or simply the ordinary, thoughtless kindness of a man who did not, in his own account of himself, believe he had done anything wrong at all. I have come to think it was probably both, in roughly equal measure, and that this, the capacity to be genuinely fond of somebody while quietly working to dispossess her, is a great deal more common in marriages than anybody likes to admit. Margaret, for her part, became warmer towards me than she had been in the whole 9 years I had known her. She telephoned more often. She sent a card, unprompted, on the anniversary of my grandmother's death, which I found, on balance, the single most galling thing that happened during the entire 11 months, and which I nevertheless thanked her for with perfect civility, because Mr. Pemberton had been very clear, in our fortnightly meetings, that nothing about my conduct during this period could be permitted to look anything other than entirely ordinary. "You are not performing innocence," he told me once, when I confessed how much I disliked the deception of it. "You are simply declining to perform suspicion you have every right not to feel yet, on the facts as they stand. They have not breached anything. You owe them nothing beyond the courtesy any reasonable person extends to family she has no proof, yet, of having wronged her." I found, oddly, that the waiting was easier once I stopped thinking of it as deception and started thinking of it, as my grandmother might have put it, as simple loyalty to a promise made in a long gallery 23 years before. Julian's third failed business venture, a boutique events company that had, in fact, been mostly a means of paying for a great many long lunches with men who called themselves investors and never once produced any actual money, collapsed in the January following our signing, leaving him with debts to 2 suppliers and a rather alarming letter from his own bank. I did not learn of any of this from Julian, who had by then developed the habit, common to men in his position, of becoming vaguer and more affectionate towards me in exact proportion to how much he was concealing, arriving home later, kissing me more warmly at the door, and saying almost nothing at all about how his days had actually been spent. I learned of it, instead, from Margaret, who telephoned me in March, her voice pitched at a warmth I had not heard from her since our wedding day, to suggest that given the trust now technically holds Winterbourne, darling, it might make the most tremendous sense, purely as a temporary measure, purely on paper, to raise a small charge against the property, just to see Julian through this rough patch. Nothing that affects your living there at all. A formality. I told her I would think about it, and I telephoned Mr. Pemberton the same afternoon. "They're asking my permission," I said. "Doesn't that rather spoil the clause? It says without my consent freely given." "It does," Mr. Pemberton agreed. "So you must not give it. Not verbally, not in writing, not by any conduct that could later be construed as consent. You are going to be, for the next few weeks, a woman who is thinking very carefully about a serious decision, and thinking, as it happens, rather slowly." I was, in fact, extraordinarily slow. I asked for more information. I asked to see the terms of any proposed charge, the interest rate, the lender's identity, so I understand exactly what we'd be agreeing to. I said I wanted to speak to my own solicitor before agreeing to anything, which was true, and which Margaret, increasingly impatient as Julian's creditors grew louder through April and into May, took to be the ordinary caution of a nervous wife rather than the deliberate stalling of a woman waiting for a rope to finish tightening around 2 throats. They ran out of patience in the 3rd week of May. I discovered it not from either of them but from the postman, who delivered, on a Tuesday morning I remember with peculiar clarity because the wisteria over the front door was finally in flower and I had been standing on the step admiring it when he came up the drive, a letter addressed to the trustees, Ashford Family Settlement, care of Fenwick & Co., which had been sent to Winterbourne House in error and which I opened. I will not pretend I felt any hesitation about it, because it was, after all, addressed to a trust of which I was the principal beneficiary, and which turned out to be a completion statement from a firm of commercial lenders in Leeds, confirming that a charge of £180,000 had that week been registered against Winterbourne House, secured, the letter noted with brisk satisfaction, pursuant to the trustees' instructions dated the 14th of April. I stood on the doorstep for a long moment, the wisteria heavy and sweet-smelling above my head, and read the letter 3 times before I quite believed it, though I had spent 11 months expecting exactly this. They had done it without my consent. They had, in fact, done it while I was still ostensibly considering the question, banking, I can only assume, on the fact that the charge would be registered and irreversible before I ever thought to check the land registry myself, which was, of course, precisely what a frightened, unworldly, trusting wife would never think to do, and precisely what I had asked Mr. Pemberton to check every fortnight since the day the trust was signed, a precaution that meant we had, in fact, the search results from the previous fortnight already sitting in a file on his desk, showing Winterbourne House entirely unencumbered as recently as the 10th of May. I did not telephone Julian in a rage. I did not drive to Ashford Manor and confront Margaret across her own drawing room, however much some smaller, less patient part of me might have wished to, might have wanted, just once, to watch her face when she understood what she had done. I made an appointment, instead, with Mr. Pemberton for the following morning, and brought the letter with me, and watched him read it twice with an expression of grave, entirely professional satisfaction that I had come, by then, to recognize very well. "Well," he said, setting it down on the blotter beside the small brass peg. "There it is. What happens now? Now, said Mr. Pemberton, I write to Fenwick & Co., as solicitors for the sole remaining beneficiary of the Ashford family settlement, putting them formally on notice that their clients have breached Clause 4 of the deed by charging trust property without your written consent, freely given, which this plainly was not, since you were, at the material time, still corresponding with them about your decision, and I have every one of those letters on file, dated and countersigned. I will enclose copies of that correspondence showing precisely that. I will then require, on your behalf, immediate confirmation that the entire beneficial interest in the trust, Winterbourne House and Ashford Manor both, together with all rents, income, and any other assets held within the settlement, has reverted absolutely to you, as Clause 4 provides, and that Julian and Margaret Ashford have been removed as trustees and hold no further interest of any kind. They'll fight it. They may try. Fenwick will look at that clause properly for the first time in his professional life and will discover, to his very great discomfort, that he drafted it himself, on his own letterhead, and that his own clients instructed the very charge that triggers it, and that his own junior filed the correspondence showing you never consented. There is no version of this, Eleanor, in which a court finds that clause ambiguous. I made quite sure of that. I have had a great many years to make quite sure of things like that. And Ashford Manor? I asked. That seems, I hesitated, because even then, even knowing everything I knew, there was some old, stubborn, unfashionable part of me that flinched at the size of it. That seems rather a large thing to take from her. For a debt of Julian's she didn't even raise herself. Mr. Pemberton looked at me for a long moment, not unkindly. She signed a document establishing joint and several trusteeship over both properties, he said, and did so, if you recall, precisely so that the arrangement would appear balanced enough to survive scrutiny, so that nobody, least of all you, would look too closely at what her son was actually being permitted to do. She did not read Clause 4 because she did not believe anyone in this arrangement had the wit, or the nerve, to write a trap that caught the trapper. That was her error, my dear, not yours, and the law does not generally concern itself with which member of a conspiracy had the better excuse. The reversion was confirmed by the courts in September, after a hearing at which Mr. Fenwick, to his very evident and rather satisfying discomfort, was obliged to confirm under oath both the authenticity of the deed he had drafted and the fact that his own file notes recorded no written consent from me prior to the charge being registered. He kept turning the signet ring on his little finger throughout his evidence, faster and faster, I noticed, each time counsel for the trust brought him back to the dates. You would agree, Mr. Fenwick, counsel asked, not unkindly but with the patient, devastating precision of a man who already knows every answer he is about to receive, that Clause 4 of your own drafting is entirely unambiguous on this point? It is drafted in standard form, yes. Standard form or not, Mr. Fenwick, does it, or does it not, provide that any charge registered against trust property without the beneficiary's written consent, freely given, triggers immediate and irrevocable reversion of the entire trust estate to that beneficiary? A long pause. It does. And your own file, which you have provided to this court, records correspondence between your clients and Mrs. Ashford dated as late as the 9th of May, in which she is still requesting further information before making a decision. Is that correct? It is correct, yes. And the charge was registered on the 14th of April, Mr. Fenwick. 3 weeks before that correspondence. I watched something go out of him, at that moment, some last, professional hope that the numbers might somehow be made to say something other than what they plainly said, and I felt, I confess, no pleasure in it at all, only the flat, exhausted relief of watching a very long piece of patient work finally arrive at the only conclusion it could ever have had. Julian did not attend the hearing. He sent, through his own newly instructed solicitor, a short statement expressing his profound regret and asking the court to note that he had relied entirely on his mother's assurance that the arrangement was proper, a sentence I read twice, in the corridor outside the courtroom, and found I could not decide whether to laugh or simply feel the old, familiar sadness of a marriage that had never, in 9 years, produced a single moment in which Julian Ashford took full responsibility for anything at all. Margaret did attend, sitting very upright in the same navy coat, I believe, that she had worn to my wedding 9 years before, and she did not look at me once, from the moment she entered the room to the moment the judge, with the particular weary clarity that family courts reserve for cases they consider entirely straightforward, confirmed that the whole of the trust property, Winterbourne House and Ashford Manor together, had reverted absolutely and irrevocably to me as sole beneficiary, and that the former trustees held no further legal or beneficial interest whatsoever. It was only as she was leaving, gathering her coat and her handbag with the brisk, controlled movements of a woman determined not to let anyone in that courtroom see her hands shake, that she finally looked at me, one long, level look, entirely without apology, in which I read, or believed I read, not so much anger as a kind of grudging, furious recognition, the look of a chess player who has just realized, several moves too late, that her opponent had been considerably better than she had troubled herself to imagine. There was one more thing that happened that September, in the corridor outside the courtroom, before the judge delivered his ruling, which I have never told anyone except Mr. Pemberton, and which I set down here only because I think it says more about Margaret Ashford than anything that came before or after it. We were both waiting, she on a bench near the window with her solicitor murmuring beside her, I nearer the door with Mr. Pemberton reading through his notes one final time, when she rose, unprompted, crossed the short distance between us, and sat down on the bench beside me, close enough that I could smell the same lavender water she had worn, I realized, at every family gathering for 9 years. I want you to know, she said, in a voice pitched too low for either solicitor to hear, that I did not do this because I dislike you, Eleanor. I have never disliked you. I did it because I watched my husband die at 51 with a house he could not afford to keep and a son he had not managed to provide for, and I promised myself, standing at his graveside, that I would never again be the sort of woman who simply accepted what life handed her and called it dignity. I did not answer for a moment. I found, to my own surprise, that I believed her entirely, not as an excuse, which I do not think she intended it to be, but as the plain, unflattering truth of a woman who had spent 2 decades being frightened and had finally, disastrously, allowed the fright to choose her actions for her. My grandmother told me something very similar about you once, I said. Almost word for word, as it happens, though she used the word trapped rather than frightened. She wasn't wrong, was she? No, Margaret said. She wasn't. She looked at her hands for a moment, the same hands that had passed me wine at 100 Sunday lunches, poured tea, signed her name on the 3rd page of a document she had not read carefully enough. I don't suppose it matters now, but I never wanted Julian to do it the way he did it. I wanted to ask you outright, years ago, whether you'd consider some arrangement to protect the family properly. He said you'd never agree if we asked plainly. He said we'd have to be cleverer than that. She gave a small, bitter laugh that had nothing of amusement in it. It appears we were not nearly clever enough. No, I agreed. You weren't. She looked at me then, properly, for the first time since the letter about the charge had arrived at Winterbourne in May. Was there ever a moment, she asked, when you might have simply told us both to stop? Before any of this went as far as it did? I thought about the study door, and the smell of lamb and mint sauce, and my grandmother's voice in the long gallery, and Mr. Pemberton's dry hands folded on his blotter. No, I said, quite honestly. I don't believe there was. Not once I understood what you meant to do. I am not certain that admission reflects terribly well on me, Margaret, but I have decided I can live with that a good deal more easily than I could have lived with losing my grandmother's house. She nodded once, as though this were the answer she had expected all along, rose from the bench, smoothed her navy coat with both hands, and returned to her solicitor without another word. 20 minutes later, the judge delivered his ruling, and I never spoke to her again except through solicitors' letters concerning the date by which she was required to vacate Ashford Manor. I have turned that conversation over a great many times since, in the long gallery, in the quiet of winter evenings when the wind comes down the dale and rattles the old windows my grandmother used to complain about and never once had properly repaired, because she said a house that did not occasionally remind you it was old was a house not worth keeping. I do not think Margaret Ashford was lying to me on that bench. I think she told me, as plainly as she was capable of telling anybody anything, the truest thing she knew about herself, and I think it changed nothing at all about what needed to happen next, and I have made my peace, slowly, with the fact that both of those things can be true at once. It was Mr. Pemberton who told me, some weeks after the hearing, over the last pot of tea we ever shared in that cramped little office above the chemist's before his retirement, something I had not known, and which I have thought about a great many times since. Your grandmother came to me, he said, the year before she died, and asked me to draft, as a private letter to be held on file rather than any part of the will itself, a note explaining her reasoning for the 10-year restriction on Winterbourne. I did not read it at the time. It was sealed, and addressed to you, to be opened only if the restriction was ever tested. I have it here, if you would like it now. The letter was 3 pages, in my grandmother's small, upright hand, and I will not reproduce the whole of it here, because some things are not improved by an audience even 9 years after the woman who wrote them has died. But there was a paragraph near the end that I have read many times since, and that I keep, still, in the top drawer of the desk in the long gallery, beneath the framed clause Mr. Pemberton later sent me. I have watched Margaret Ashford at 3 family weddings and 1 funeral, my grandmother had written, and I have concluded that she is a woman who has spent 20 years learning to want things quietly, which is a far more dangerous education than learning to want them loudly, because the world forgives loud greed and rarely even notices the quiet kind until it has already succeeded. I do not know whether her son will prove as patient as she is, or as careless. I suspect, knowing Julian's father before him, that he will prove considerably more careless, and that his carelessness, one day, will be the instrument of his mother's undoing far more surely than any cleverness of mine could ever be. My task, Eleanor, is not to prevent them from trying. People like Margaret Ashford cannot be prevented from trying. It is not in their nature to leave a fortune unexamined for weaknesses. My task is only to make sure that when they try, the house is standing on ground I have already prepared, and that the very carefulness they bring to the theft is the thing that finally exposes it. I sat for a long time with that letter in my hands, in the quiet of Mr. Pemberton's office, understanding for the first time that I had not, in fact, invented clause for it all. I had simply been the instrument through which a promise made in a long gallery 23 years earlier finally came due, my grandmother's ground, prepared decades before either Margaret or Julian had ever set foot on it, and I had done no more, in the end, than walk the path she had already surveyed. I still live at Winterbourne, in the room with the long gallery and the mullioned windows, and I let Ashford Manor to a young family from Leeds who keep chickens in the old walled garden and have never once asked me why a woman on her own owns 2 great houses 11 miles apart. I do not think I will ever tell them. Some stories are not improved by explanation, and this one, I have found, is best kept exactly where my grandmother first gave it to me, in the space between what a document appears to say and what it actually does, which is, when you come to examine it properly, very nearly the whole of English law, and very nearly the whole of English family life besides. Julian and I were divorced the following spring. He did not contest it with any energy. I believe, by then, he had begun to understand that the marriage had ended not on the day the decree was filed but on the afternoon, 11 months earlier, when he had signed a deed without reading past the schedule of assets, trusting, as his mother had trusted, as I imagine a great many careless, confident people have trusted, in libraries and solicitors' offices since the whole ungainly business of English property law began, that the middle of a document was simply where the lawyers put the parts that did not matter. I gave Margaret 6 months to find somewhere else to live, though the court had granted her nothing beyond a brief right to remain that I could have ended within the fortnight had I chosen to. I am not, I said to Mr. Pemberton, when he raised an eyebrow at the generosity, a cruel woman, whatever else I am. I simply prefer, where I have the choice, to be the sort of person my grandmother would have recognized. She left Ashford Manor in March, and I have not seen her since, though I am told, by people in the village who still enjoy the story rather more than I do, that she lives now in a rented cottage near Grassington, and tells anyone who will listen that she was the victim of a scheming, ungrateful daughter-in-law who never deserved either house. I let her have the story. I kept the houses. Mr. Pemberton retired the year after the hearing, and sent me, as a leaving gift, a single sheet of paper, framed, on which he had typed, in the dry, precise, entirely unsentimental hand I had come to love him for, the whole of Clause 4, with a note beneath it that read simply, for Eleanor, who understood, better than most people twice her age, that the 4th clause is the one nobody reads, and the only one that matters. It hangs now in the long gallery, beside the window where my grandmother once took my chin in her hand and told me that the house would outlive whoever tried to take it from me, provided I was clever enough to let them try. She was, as she generally was, entirely right.